Hello. As you may have already heard, my name's Lou Virelli. I'm a professor of law at Stetson University College of Law in Gulfport, Florida. I teach courses in constitutional law and administrative law, and I've been fortunate enough to be invited several years in a row to this program to talk about the role of the Supreme Court in our constitutional democracy. What does that mean? Well, we talk a lot now about the Supreme Court, way more than we used to. And we talk a lot about the Supreme Court when we're talking about really important issues, things that people really care about. The election, individual rights, the powers of government. And the question is, why is this group of 9 people allowed to make decisions that are so important, especially when we don't elect them, and we have almost no control over how they're going to come out? And in fact, sometimes they decide the most important things governing our lives that matter to us the most by a one-person majority, by a 5-4 vote. How did the court get to this place in our constitutional democracy, and what do we need to understand about it to have it all make sense? The start is in 1803 in a very famous case called Marbury v. Madison. I spend at least 2 hours on just this case with my law students, so I'll spare you that. But it's a really interesting case, part because of the story and part because of what it did for the Supreme Court. It's unquestionably one of the most important cases in American constitutional law. One of the most interesting things about the case is who was involved. So on one hand, we have President John Adams, who was the second president of the United States after George Washington. We have John Marshall, who was the Secretary of State to John Adams and the Chief Justice of the United States for some 3+ decades afterwards. He is regarded as the best and most influential Chief Justice we ever had. So John Marshall's a really important person, but he starts as John Adams, Secretary of State. William Marbury, whose name is on the case, Marbury v. Madison, Marbury is sort of an innocent bystander to all of this. He is a nominee to be a state court judge in D.C., effectively, what we call a justice of the peace. Thomas Jefferson, you've heard of him. He's on the $2 bill at least and has a monument in D.C. He's the third president. He's on the other side of this dispute, the other side from President Adams and John Marshall, and James Madison, who is Thomas Jefferson's Secretary of State. James Madison also is understood to be the father of our Constitution and the 4th president. So some of the most important people in American history all in one case. So what happens? Well, I'm talking to you now just about a week before the inauguration of President-elect Joe Biden. So I am talking to you in mid-January in what we call the lame duck period of our presidential cycles. So as you know, the presidential elections happen every 4 years in November. But then there's a period of time between the election and when the new president is sworn in. We call that the lame duck period because it could very well be that the president of the United States is still president but knows he or she is not going to be by January 20th. Well, in the 1800s, the lame duck period went from November way past January 20th, where it is now, all the way into April. So you had a president, in this case John Adams, lose an election, the election of 1800. If you're familiar with the musical Hamilton, there's a great song about it, rap battle actually about it. He lost an election in November of 1800, but was still president until April of 1801. So he's got a very long time where he's in charge and knows his time is up. And not only is his time up, but he lost to Jefferson, who was a member of the opposing party. And much like today, in the early 1800s, the two parties hated each other. So Adams knew that when he left, much of what he had done or accomplished, in his view, while he was president, was going to be undone by Jefferson and the Democratic Republicans. That was the name of his party. Adams' party was the Federalists. No surprise, John Marshall, to go back a slide, is a Federalist. He is John Adams, Secretary of State, and James Madison is a Democratic Republican. He is Thomas Jefferson, Secretary of State. So what does Adams do? Well, he does lots of stuff. One of the things he does, he makes John Marshall Chief Justice in January of 1801. So before Adams has to leave the presidency, he makes sure that he gets to pick the Chief Justice. Now, interestingly, Marshall's also still Secretary of State, which is wildly unconstitutional. But nobody said anything at the time, and it just sort of came to pass. The other thing Adams does is he starts appointing lower court judges. So as you know, you've certainly heard in the news, the president is in charge of picking our federal judges, and the Senate has to confirm them. Well, when Adams was president, the Senate was also dominated by his party. So it was a Federalist Senate and a Federalist president. So Adams knew that anybody he picked to be a judge while he was still president would be passed through the Senate pretty quickly and then would be there for much longer after he left. If they're federal judges, they'd be there for life. And if they're D.C. judges, like Marbury, they'd be there for at least 5 years. And that was true for Marbury. So what Adams starts doing is picking these midnight judges. As he's going out the door in April of 1801, as Jefferson's preparing to become president, Adams starts filling all the judgeships he can think of with Federalist judges, members of his party who will be in power after he's gone. This is not unusual, but it's something that Adams did. It's legal. He's allowed to do it. But they were called the midnight judges because they happened sort of as the clock was turning midnight on his presidency. How do you do that? Well, Adams has to nominate them. Then their name goes to the Senate to be confirmed, just like we see happening in modern day. That happened very easily. Then Adams signs the commission that says this person is now a judge. He stamps it with his stamp to show that his signature is real. And then the Secretary of State is in charge of delivering the commissions, bringing them to the judges so that when the judges show up for work, they have their commission and they can say, yes, it is true, President Adams signed this for me. Secretary of State Marshall goes to deliver the commissions. There are a lot of them. He asks his little brother for help, and his little brother blew it. His little brother blew it at least a few times. One of the mistakes Secretary of State John Marshall's little brother made was not to deliver William Marbury his commission from President Adams. So Adams then leaves office, and Marbury's commission, this is why I have the Stevie Wonder album up there, is not signed, sealed, and delivered. It is only signed and sealed. And Adams' commission for Marbury is not delivered. Madison and Jefferson are now in charge. Jefferson's the president. Madison is his Secretary of State. Marbury wants to go to work, and they won't let him sit as a judge. And he says, well, I was picked by President Adams, and it was voted on by the Senate, and President Adams signed my commission, and he stamped it. He just didn't deliver it. Secretary of State Madison, you give me the commission, and then I can go be a judge. And Madison says, absolutely not. We're in charge now. We don't want you to be a judge. You're a Federalist. You're not a Democratic Republican. We're not giving you this commission. This is just part of sort of the rancor of the election of 1800. As Jefferson takes power, a lot of what the Federalists had accomplished in the years before, whether good or bad, right, was being undone. And in fact, Jefferson's Congress shut down the Supreme Court for 2 years because it was a Federalist Supreme Court. It was made up of Federalist justices, including Chief Justice Marshall, and the Congress that was loyal to Jefferson didn't want the Supreme Court to sit. Now, that is also unconstitutional, clearly unconstitutional, but again, because the Supreme Court at this point in history was not as powerful an institution as it is today, the Jeffersonian Congress was able to shut down the court for 2 years, and very few, if any, people raised too big a fuss about it. Well, how could the court not be so powerful? You say it's part of the Constitution, it's created by the Constitution, because the court's power comes from its ability to persuade us. The court doesn't pass any laws. They don't have any money to dole out the way Congress pays for things and gives and creates programs. They don't have any guns or law enforcement officials. They can't make us do what they want. The court's job is to resolve disputes and to say what the law is. That is only a powerful thing if the people you are speaking to, the public, cares and trusts your judgment and thinks you are important. Clearly, the Supreme Court in 1801 didn't have the kind of power that they do today. And President Jefferson knew that, and his Congress knew that, and they refused to deliver Marbury's commission, and they shut down the court for 2 years. That's why, although William Marbury was given his commission in 1801, the case of Marbury v. Madison doesn't start till 1803. What does that case look like? Well, Marbury sues James Madison in the United States Supreme Court. Now, that's unusual. Usually cases don't start in the Supreme Court, and we'll talk a little bit about that later. But he sues him directly in the Supreme Court and says, I want my commission. Give it to me. And Madison says no. And really, it's Jefferson saying no, because Madison works for Jefferson. And Jefferson says, no, I'm not giving it to you because I don't want you to be a judge, and it's my decision now who gets to be a judge. And the fact that President Adams didn't deliver this to you means you're not a judge. You never were. Until you get the commission, you're not a judge. Until it is delivered, to quote Stevie Wonder, you're not a judge, so you're not a judge. Marbury sues and says, I want my commission, and then the question falls, ironically, to Chief Justice Marshall. So you see I have this conflict of interest cartoon here. Chief Justice Marshall, who was also Secretary of State Marshall, who was the one who was supposed to deliver Marbury's commission and didn't, is now deciding whether Marbury is a judge or not. In a court that lots of people think isn't really that powerful and doesn't need to be listened to. Look at the fact that they were just shut down for 2 years against their will. The case is very interesting because of the people involved, like I said before. You have Congress versus the president. You have the president versus the court, and you have the court versus Congress. All three branches have a dispute with one another. The most obvious is the president versus the court. President Jefferson wants to do what President Jefferson wants to do, and that's not unusual for presidents. They're used to getting their way. President Jefferson doesn't want to deliver the commission, and the question is, can the court make him? That was a very dicey proposition. And in fact, there's this quote here from Andrew Jackson that happened 20 years later when Chief Justice Marshall made a decision in a case involving Native Americans in Georgia that Andrew Jackson didn't like. And he said, John Marshall has made his decision, now let him enforce it. Which, of course, Jackson knew that Marshall couldn't do because he doesn't have any guns or law enforcement officials. All he's got is the power of being a judge. So Marbury v. Madison is the first example of the president and the court being at odds. It's Congress versus the president because Congress passed a law that said the president can be sued in court. When we first started the country, there was a big debate about whether or not the president should ever have to answer to a court. They're the president. They are the executive branch of government. Why should they answer to another equal branch of government? Well, Congress passed a law that says you can sue the president. And President Jefferson had a problem with that. And you've got the court versus Congress. Congress said that Marbury's case could start in the Supreme Court. You didn't have to go through all the lower courts like we normally do. You didn't have to have appeals. You could go straight to the Supreme Court because you're asking for the kind of relief, you're asking for the kind of help that the Supreme Court can give. So in this kind of case, you should be able to go straight there. Congress passed a law that said that. All of these things were on Chief Justice Marshall's plate. Can I order the president to do something he doesn't want to do? Can Congress tell the president you're allowed to be sued? And can Congress tell us, the Supreme Court, which cases start here and which cases don't? Whether you have to go to a lower court before you get here, or you can bring a case directly to us. Marshall's in a very delicate situation. He knows that if he rules against President Jefferson and says, deliver that commission to Marbury, Jefferson is going to tell him no. He's going to ignore him. And what's the Chief Justice going to do about it? He can call the FBI. He can call the U.S. Marshals and say, go make them do it. But are they going to really draw guns on the president and make him do something? No, the president's in charge of the executive branch. The president's in charge of all of the law enforcement in the country. So Marshall knows that if he orders Jefferson to do something Jefferson doesn't want to do, he's going to be ignored. And if the court gets ignored in 1803, then it never becomes the kind of important equal branch of government that it is today. He also knows that this is an opportunity for him to be the decider on a very important constitutional question. The question is, when do you actually become a judge under the Constitution? Which part of the process has to be completed before you are legally a judge? That's an important legal question. That's an important constitutional question. And Marshall wants to be the decider. He wants the court to have the power to make that decision, to be the constitutional interpreter. But he knows that if he does that, or if he makes a decision that says what the Constitution means and he gets ignored by the president, none of it matters. He was ignored, he was rendered powerless, and he can make all the proclamations he wants. It won't matter if the president doesn't agree with him. You can't be an equal branch of government if you need the president to agree with you to follow your instructions. So what does Marshall do? He makes two rulings. He says, on the one hand, we, the court, have the power to say what the law is. That's the most famous quote from Marbury v. Madison. It is emphatically the power of the judicial department to say what the law is. Courts interpret the law, and they interpret the Constitution, and the president is bound by the law just like everybody else is. And of course, we've heard a lot about this as we go through various impeachment proceedings, right? The president in America is not above the law. Part of that is because Marbury said it's true. The court in Marbury said so. So we say what the law is. The president is subject to the law. We are in charge of, we are the final word. We are in charge of what the Constitution means by being the final word on constitutional questions. That is a huge sentence, and it makes the court much more powerful than anybody necessarily thought it was, or than it had to become. The court could have faded into sort of a younger sibling branch of government, a less powerful branch of government. But if the court gets to tell us what the Constitution means, now they are clearly equal, because they can tell Congress, you got it wrong, your law is unconstitutional, and we strike down that law. That law is now no longer valid because we, the court, said it's unconstitutional. That's a huge power. Marbury says that. The court in Marbury says Congress's law that says you can come straight to the Supreme Court with a case like this is unconstitutional. And we can talk about why later. If you want to find my email address in the email, I'll be happy to talk to you about that, but that's beyond the scope of this presentation. But the bottom line is, Chief Justice Marshall says in Marbury, Congress's law that allows us to hear this case first, without an appeal, but first, is unconstitutional. And because we are in charge of what the Constitution means, and because we say what the law is, when we say a law is unconstitutional, not only can you not bring this case to us, like the statute says, like the law says you can, but the law is now invalid. We basically erase it off the books. That's one branch, the court, erasing the work of the other branch, Congress. It's a huge power. Marshall says we can do it, and we're doing it here. Congress's statute that says you can start this case in the Supreme Court is unconstitutional and therefore invalid. But the next thing he says is, because this case can't be brought here originally, Marbury, you lose. We don't have jurisdiction. We're not allowed to decide Marbury's case because Congress's statute is unconstitutional. We just told you that. We just invalidated it. So even though we're in charge of what the law means, we're in charge of what the Constitution says, Marbury, you lose because you shouldn't have come here in the first place. You should have started in the lower courts and come here on appeal. By having Marbury lose, Jefferson gets what he wants. Marbury losing is Madison and Jefferson winning. If Jefferson wins, he's going to follow the court's lead. The court gave him what he wanted. Marshall's decision is genius because on the one hand, he claims the power of what we call judicial review, the power for courts to be the final arbiter, the final decision maker about what the law means, and to invalidate, to strike down acts of Congress or actions by the president or the executive branch that are unconstitutional. The court can undo them, and we see it happen all the time in modern day. And having Jefferson win, so Jefferson goes along with his decision. That balance is what got the court to where it is today, the arbiter of all of these important decisions, and one of the most, and a very important, at least equal, branch of government. How did Marshall get the constitutional answer in Marbury v. Madison? He uses all sorts of tools. He uses the text. What does the Constitution say? But if you've read it, you know the Constitution doesn't answer most of our most difficult questions. He looked at historical practice. He looked at what we call constitutional structure. How do we read the Constitution so that all the different parts make sense together and we're not forgetting any? Public policy, what's the best way for the Constitution to work, to do the greatest good? And what best suits our democracy? And he held that yes, as soon as Adams was done signing the document, Marbury was a judge, because that's the only way for that decision to make any sense. Otherwise, the Secretary of State could decide that Marbury is not a judge, just by not delivering the piece of paper, when it's really Adams' job to decide who a judge is. It's the president's. So he said, as soon as he signs the piece of paper, you're a judge. And how did he decide that? Text, historical practice, constitutional structure. What does that tell us about the separation of powers? The fact that these decisions have to be made by interpreting the Constitution, and that the court's place in it is very delicate. It means separation of powers is a balance. It's an ongoing balance. And we see this all the time. Congress legislates, the executive branch enforces the law, and the judicial branch interprets the law. But lots of times these things overlap, and sometimes you have one branch trying to tell another branch what to do. Those conflicts are where we really learn how the separation of powers works, and what we learn over and over and over again is that most of the time it's not a matter of power or rules. It's not just law that tells us who wins. It's a balance and a compromise between the branches. So why does this all matter? It matters because it helps us understand why the court does things that it does. So when we study constitutional law, we often study it through the Supreme Court, because the Supreme Court, after Marbury, is in charge of telling us what the law means, including the Constitution. So most of your studies of what the Constitution means will be about what the court has said. But the court started out as a not terribly powerful institution. We just talked about that. And now it's claimed this power for itself that's pretty severe. And it made Jefferson nervous, right? It is a very dangerous doctrine to think of the judges as the ultimate arbiters of all constitutional questions. It would place us under the despotism of an oligarchy. We've heard words like despotism a lot recently. What does he mean? He means that if 9 unelected, life-tenured judges are in charge of all of our constitutional questions, all of a sudden we start to feel less like a democracy, less like we're in charge of our own government. As we saw with Andrew Jackson's quote, Marshall's made his decision, let him enforce it. As we saw with Jefferson's attitude in Marbury, he was never going to do what Marshall told him just because Marshall told him to. We see the delicate balance the court walks, the concern about the court being too powerful, yet the need to have a court be the final decision maker because somebody has to be the final word. We have to know what the final constitutional rule is to resolve some of these disputes. Understanding that the court's job is as much about protecting its own authority or making sure that it is capable of doing its job helps us understand why the court behaves the way it does sometimes. So what are Marbury's lessons and effects? Lessons: the court is always concerned about protecting its own legitimacy. And I don't mean that in a selfish way. It's not the court trying to be more powerful. It's the court trying to make sure that it behaves in a way that people will listen to it. If people don't listen to the court, it loses all of its power. The court can't force anybody to do anything. All they have is paper and pen. Alexander Hamilton famously says that the court has neither force nor will, but merely judgment. The executive branch has all the guns, Congress has all the money, the court just has a bunch of paper and pen. So how do you protect that legitimacy? You act in a way that where people will follow. Doesn't mean you always do what they want. Doesn't mean that every case is Marbury where the president has to win. We've seen the president lose lots of cases. But you have to develop a reputation, a place in society where people will follow your lead. Their job is to decide cases. So what is the other thing that Marbury did? Marbury picked a winner. The Supreme Court in Marbury said, William Marbury, you are not a justice of the peace because you started in the wrong court. You shouldn't have come straight here. So you lose. Every Supreme Court decision has a winner or a loser. They can't call it a tie, and they can't forget about the dispute. The dispute is what allows them to be involved in the first place. The other lesson is that we can be supreme. We can do judicial supremacy. It's what I described to you. Judicial supremacy means we are the final word on what the Constitution means. Marbury taught the court that this will work if you are careful about it, if you take it seriously, if you explain yourself, then you can play the role of the final decision maker and have it work and have people listen to you. And that's the ultimate effect. Future Supreme Courts, had the power to make these decisions, and people follow them. Overwhelmingly in American history, the Supreme Court is the most popular branch of government, the most trusted one, even though they're not elected, and even though they can never be taken out of office except for impeachment. So now that we understand, or we're thinking about the court in this way, and where in its place in government, some of the challenges that it faces, some of the effects it's trying to achieve, I think we can sort of illuminate this reality. We can sort of describe or give an example, that's a better way to say it, of what I'm talking about by looking at a litany of race cases over about a 70 or 80 year period, famous cases in the Supreme Court. And I want to be clear. Two of these cases are two of the worst decisions in American history. Plessy and Korematsu, the next case I'm going to talk about, are both widely regarded as terrible decisions. I think it's not controversial to describe them as evil decisions. In fact, the Supreme Court has apologized for Korematsu. It never officially apologizes for its decisions. It did apologize for Korematsu. So I'm not excusing the court's decision. I am hoping to have you all think about some of the things that might be going through the court's mind when it is faced with a very controversial question. So it doesn't mean they did the right thing, but I think understanding how the institution works can help us maybe understand better what's going on. So Plessy is a case where Homer Plessy, who is of African American descent, he is very light skinned, which is why he's such an interesting plaintiff in this case, because he didn't appear to be black. But he got on a streetcar that was whites only in Louisiana. And he was arrested for doing so because it was a segregated streetcar. This is the Jim Crow South, right? Separate but equal. And he sues and he says, the 14th Amendment says equal protection of the laws. The Constitution says that on the basis of race, you can't discriminate against me. And it's 1896, remember. And Reconstruction is over and largely been reversed by Jim Crow. This is all tragic and wrong in every moral and political sense, but it's true. And the court makes a decision. And what the court says in Plessy v. Ferguson is the 14th Amendment is about political, not social rights. So all the 14th Amendment can say is you are not allowed to be expressly and legally denigrated or treated worse than people of another race. What the Louisiana law did, according to the Supreme Court, was just create two different cars for people of different races. So everybody got to ride the streetcar, it's just a matter of which car. Now we all know, of course, that the reason this law was passed was because white people didn't want to ride on the streetcar with people of color. And we also know that the white cars were far nicer and better maintained than the black cars. None of those things are in dispute anymore, and there's no question that this law was simply racist and in the worst possible way. But what the court says is that the legal question is just about whether different races get different things or the same thing. Separate but equal. And they say here, the streetcars are close. They're equal in a general sense. We can't go through every square inch of the car and make sure they're equal. They're equal. They're both streetcars going to the same place. And the fact that black passengers are riding in a car and made to feel inferior might be true, but isn't the law's problem. Social equality is different than legal equality. Now, the dissent, one justice disagrees. And that's that quote on the bottom of the slide. He says, our Constitution is colorblind. It can't tolerate classes among the citizens. You can't treat white and black people differently. That inherently is discriminatory because everybody knows who's in charge. White people wrote this law, and white people are trying to exclude black people from being in their own company, from being in their company. But the majority of the court in 1896 says the law says everybody gets their own car. The law, the political, legal rights are the same. That's good enough for us. And they ignore the social part of it. Go to 1944. We're now at war with Japan and Germany and Italy, by the way. And on the west coast of America, Japanese Americans are being imprisoned in internment camps. And the military says this is necessary because we don't know who's a spy for Japan, and we don't have time to figure it out because it's an emergency, so we're going to put everybody in camps so they can't harm us. It's a very powerful reason, right? We are at war. Our national security is jeopardized is a very powerful reason to do something. But the challenge by Mr. Korematsu was, incidentally, Mr. Korematsu served in the Army, was a model citizen and clearly an American, and I shouldn't limit it to him. I don't know that there was any evidence of Japanese American spies uncovered as a result of internment. It was a terrible policy. As I said, the Supreme Court's apologized. But what did the court say? The court said, first of all, you're not being discriminated against on the basis of your race. You're being discriminated against because we are at war with you. So that's not the same thing. And it's an emergency, and we're not going to tell the Army that they're wrong because the Army knows better. The Army knows what's dangerous and what isn't. The Army's in charge of the war. We're not going to interfere, even though we understand this is a severe thing to do. And they allowed the internment of Japanese Americans. Now, again, since then, we have not only apologized officially as a country, but there have been some reparations, some paid in the 1980s by a law signed by President Reagan. But this is a very dark mark on America. But the rationale is important. We're not going to interfere with the military during a time of war. Now, of course, this ignores the fact that we're also at war with Germany and Italy, and no German Americans were in prison, nor were any Italian Americans. And in fact, German spies were found on the east coast of America, in Florida and Long Island, I believe. But at no point did we consider locking up Germans. Why? Because this was a racist policy against the Japanese. There's no question about that. But the court was afraid to overturn the law because the military said it was necessary and because we were at war. One way to think about that is maybe the military won't listen to us. Now, of course, the dissent is right in Korematsu. The dissent says, of course this is about race. See the Germans and Italians. You're only locking up the Japanese. Even if you can't tell person by person who's likely to be a spy, what about the very old and the very young? Infants are not spying. The sick and elderly aren't spying. Why aren't we making any distinctions at all? This is nonsense. But the majority of the court said, we're not going to interfere because the military says so and because it's an emergency. What are we hearing about? What is the court thinking about? Well, the majorities in Plessy and Korematsu are worried about compliance. In a national security situation, will the military follow our lead? Or are we just shouting into the wind, so to speak? Do we want to be responsible if we invalidate this program and somebody ends up spying for the Empire of Japan and harming Americans? In 1896 in Louisiana, are we able to solve this social unrest, this bigotry problem, or are we going to cause riots in the streets? That's not a justification for what the court did. There is no justification morally for what the court did, but it's an explanation that's slightly more complicated than the justices were all racist. It's overwhelmingly likely they were. But I still think it's important to understand how the court's place in democracy may affect some of these questions. What are the dissents thinking about in those cases? Quite exactly the opposite view of the court's position. The majorities are acting as if they need to protect their legitimacy and make sure they get complied with. And the dissents, the people who have come out the right way in Plessy and Korematsu, are saying, you got it exactly backwards. We're the only ones who can do this. The voters won't do it. Congress won't do it because most Americans who are voting, at least, are racist and like this policy. So the Congress isn't going to fix it. The president's not going to fix it. We need to fix it. We're the only ones who can. And you see a dispute over where the court fits, and you see which side wins. The passage of time, as with many things, helps. In 1954, after decades of at the time, Attorney Thurgood Marshall, later Justice Thurgood Marshall, litigating cases about separate but equal, challenging separate but equal from Plessy in the courts. In 1954, we finally get to Brown v. Board of Education. And what happens in Brown? Well, we know that public schools are segregated in the South, and in fact are segregated, as a matter of fact, all over the country. Boston, Philadelphia, New York. Right? White children and black children are not going to public school together in most of America. And in Kansas, among other states, there's a challenge brought. Brown versus Board of Education of Topeka, Kansas is the full name of the case. Now, if you just use Plessy v. Ferguson, separate is equal. Black schools, white schools, they're separate, but everybody gets to go to school. Political, not social rights. What's the problem? By 1954, we see a change. Thanks to Justice Marshall, building this argument and persuading courts and making the case over the years. The first victory is actually in law schools. He convinces the Supreme Court in a case called Sweat v. Painter a few years before Brown that black law schools in Texas are not the same as white law schools. Forget the fact that the facilities weren't even close. And of course, all these policies are racist, right? That's why they exist. But he says even as a matter of law, being a black law student in Texas gives you only a fraction of the professional opportunities, if any, as being a graduate of a white law school, because the white law schools where all the lawyers are from. They're doing all the hiring. They're hiring from their own schools. Black law schools aren't generating professional opportunities. They're nothing alike. They're not even equal. They might be separate, but they're not even close to equal. A much more sophisticated understanding of equal, but the court was ready to do that in 1952, and they did it with adults first. They did it with law students. Then we get to public school students in Brown v. Board, a much larger segment of the population. And the court says, with the changing times comes a changing view. Public education must be considered in its present role in American life. When Plessy v. Ferguson was decided, most states didn't have meaningful public education for everybody. By 1954, public education is the norm. And they say, what the problem with segregated schools is not that they're separate, they're not even close to equal. And the reason they're not close to equal is a number of reasons, one of which is students in black schools are stigmatized. They are taught, by virtue of being separated, because they are separated, they are taught that they are less than white students. And that stigmatization, that denigration, that criticism, that embarrassment of black students affects their entire life, because a meaningful education is the key to the development of a full and free life. The court in Brown does something very different than the courts in Plessy and Korematsu. It doesn't defer to the legislature. It takes a stand. And it says, times have changed. This cannot exist in modern society. They waited till 1954 for a reason. And they made their decision. A very different view of their role, or at least a more, all of a sudden the dissents in Plessy and Korematsu seem to be the majority in Brown. But there's a catch. And this sort of highlights what we've been saying about the role of the court in American democracy. The reasoning in Brown is unanimous, and that's on purpose. Chief Justice Earl Warren was brand new as Chief Justice, the former governor of California. He insisted that the court's decision in Brown v. Board be 9-0. It would not have been if the justices had just voted on their own consciences or what they thought was the right thing to do. He said it has to be 9-0 because the public's going to be looking to us, and a lot of people are going to hate this decision, and there's going to be social unrest. We're going to make a lot of people angry and likely violent, which all happened. And we can't have them saying only 2/3 of the court even believed it. We want the entire power of the Supreme Court to be behind this decision. That reflects an understanding of the court's power. The court is more powerful when it's 9-0. It's less powerful when it's not. The other example is that the remedy didn't work. So in 1954, the court says you must desegregate schools. Segregated schools are unconstitutional. It took decades for that to become a reality, and many will argue, and they're right in many ways, desegregation isn't over. American schools are not fully desegregated, even today, because these forces are so powerful and it's so hard to do. So what do we see Brown as an example of? The court being aggressive in its place in society, but also recognizing that 9-0 matters. And the fact that they recognize that 9-0 matters means they understood that there was a value to being 9-0. People weren't going to listen just because they said so. And people were still going to be really angry. They wanted to be as clear as humanly possible. They also understood and learned that without help from the legislatures and the states and the executive branch, Brown v. Board was just going to be an instruction until somebody else could help make it a reality. And that's when you see busing programs, and you see rezoning, and you see the courts piece by piece try to create remedies to fix this problem. But Brown didn't fix it overnight, and that sort of again highlights where the court fits in this thing. It is an incredibly powerful force, but it can't change society on its own overnight and never has been able to. The good news is Brown is the law. So then what happens? What follows after Brown? Well, you get cases like Loving v. Virginia, which is only 50 years ago. 50 years ago, in the state of Virginia, it was illegal for a white and a black person to marry each other. You couldn't legally be married, and in fact, you could get sent to jail. The Lovings were married in the District of Columbia in D.C. For those of you that know the geography, it's right across the river from Virginia. They went to Virginia as a married couple, and they were convicted of violating what are called anti-misogyny laws, laws that prohibit interracial marriage. Incidentally, the law only prohibited white people from marrying people of other races. Black people could marry Asian people. South Asian people could marry people of African descent or other Asians or Europeans. It was a matter of white people not being allowed to mix with people of color. That's what Virginia outlawed. And it was challenged in the Supreme Court. And the Virginia state courts were not ready to move on the way the Supreme Court had been in Brown v. Board. They said things like, Almighty God created the races and he put them on separate continents and that's where they belong. That's a quote from the lower court's decision in Loving. But by the time we get to the Supreme Court, thanks to Brown and another 13 years and the civil rights movement, which has been going on for at least 15 years by the time Loving's decided, been going on full bore for at least 15 years. The Supreme Court says no. No, we can't allow this under the 14th Amendment. What's interesting is the argument that they faced. The argument from Virginia was, this isn't racial discrimination. White people lose too. Mr. Loving is white. He wants to marry Mrs. Loving, who is black. He can't marry her, just like she can't marry him. Both white and black people lose in this situation, so it's not discrimination. It's not race at all. That argument would have been very persuasive if we were talking about legal versus social rights, if we were in a Plessy universe. And that's why that argument was made. But the Supreme Court in 1967 is not the Supreme Court of 1897. The Supreme Court says that's nonsense. There can be no question but that Virginia's statutes rest solely upon distinctions drawn according to race. There is no legitimate purpose other than racial discrimination to justify this statute. The only reason you did this, Virginia, was because of race. The fact that a white person also loses doesn't mean the Constitution doesn't care. The Constitution doesn't want you treating people worse because of their race. That's what you're doing. This is not allowed. The statute is struck. The power that Chief Justice Marshall identified in Marbury v. Madison, the power to invalidate a law, was used in Loving to protect interracial marriage. A long haul from Plessy v. Ferguson, but a different environment, and a court that has developed its reputation, its legitimacy, that has made big decisions that the public has followed in the past, and that is using its power to do, I think, what is unquestionably the right thing, even though it may not have been popular. What is the legacy of Brown and Loving and the court sort of being more assertive in this space? Affirmative action cases, LGBT cases, gay marriage cases like Obergefell, and gender discrimination cases. All of those protections, protection against gender discrimination, the permissibility of some affirmative action claims, the right of legislatures to say, this group has been denied something for so long, we want to help them get it. And protecting the gay, lesbian, bisexual, transgender Q community from discrimination, LGBTQ community in Obergefell. All of those decisions are the result or the legacy of the court establishing a place in Brown and Loving where they will be adhered to even when they make controversial decisions. It's centuries of credibility that they're trading on. What about the other concern we talked about? That we don't want a runaway court either. We want to make sure that the court doesn't think that it can do whatever it wants. We can't fire justices. We can only impeach them, and that's hard to do. We don't elect them, so we can't be sure what they're. We don't get to pick them ourselves. The president picks them. How do we restrain the court? Well, the short answer is that the court ends up restraining itself. Why is that important? Because of the reason they do it. The court restrains itself to protect its reputation and legitimacy. If we see the court only getting involved in situations where it feels comfortable that it belongs, then we have more reason to follow their lead. Now, these themselves can be controversial. We'll talk about that in a minute. But what are the limits on the court's power? One, they can only hear cases and controversies. That's in the Constitution. What does that mean? That means there has to be a dispute. There has to be a fight. And they have to pick a winner. There has to be a plaintiff and a defendant. I can't call up the Supreme Court and say, I've got this really interesting legal question. Will you tell me the answer? They won't do it. I have to be in a fight with somebody else about this legal question, and I have to have something to gain or lose. I have to have a stake in the case. That's called standing. You've probably heard that in the news. That's one limit on the court, because they can't just go around announcing legal things. They can only resolve cases, and in the process of resolving a case, in the process of resolving a dispute and picking a winner, they will tell us what the law is, because the law will justify who wins and loses. The other limit is what we call political questions. That's a term of art. That's a legal term. It doesn't mean only questions involving politics. What it means is questions that should not be for the court, questions that belong with Congress or the executive branch. So they're political that way. They're political that the political branches, the elected branches of government, Congress and the president, should really be in charge of them, and the courts shouldn't have much to say about them. What kinds of questions have become political? Well, this becomes really interesting in modern constitutional law, because we're seeing a lot of these. Congressional districting. Who gets to decide how Florida's districts are divided, right? How we decide who votes for which members of Congress. The power of drawing those lines is really important, because if you get to draw the lines, you get to decide whether most of Florida's Congress people will be elected by majority Republican or majority Democratic districts, for example. The court's been asked to intervene, and the court has said no. The decision about how a state organizes its elections geographically, how it divides itself up into different congressional districts for the House of Representatives, is its own business. War powers. When can the president decide to use the power of the military? That's the president's job. Congress, the courts want nothing to do with that. And impeachment. Talk about current events. How does a president or another official get impeached? How does the Senate try that impeachment? What are the standards for conviction? All of those things are ultimately up to the Congress. Why? Because the court has said that's a political question. That's something we shouldn't deal with. Why? Because if they get involved, they're going to be they run the risk of applying standards and tests that are too squishy, that are too policy-based, that are too political, and that are better decided by the experts in this case being Congress and the president. We've seen all these things come up recently. The drawing of congressional districts was just decided in a case called Rucho v. Common Cause. It was a case involving North Carolina. It was and Maryland, really, but it was unquestionable that in both those states, and it was undisputed, it was admitted by the people who did it, that in North Carolina, the districts in North Carolina were drawn so that the majority of Congress people from North Carolina would always be Republican. So much so that less than half of the voters in North Carolina got to elect like 63% of the seats in the state. What are we saying? We're saying that those districts were designed to be Republican, and the opposite in Maryland. The districts were designed to be Democratic. It's just a question of who's drawing the districts, Republicans or Democrats. The court said, we think this is a problem. We understand the concern, but the decision about where to draw congressional lines is not something that judges can do. There's no easy law to apply. There's no clear objective test. We're going to stay out of this altogether. Now, only 5 of the Supreme Court felt that way. The other 4 were furious. They said there's lots of ways to do this. And in fact, the lower courts had been doing it like crazy, and they'd had no trouble saying, this is the test we're going to use, and you broke it, which is generally what courts do. Here's the legal test. Did you satisfy it? Did you meet it? But the Supreme Court said, no, we're out. We're not going to decide any congressional districting cases that are based on politics as opposed to race. So North Carolina was not dividing up its districts based on race. It was doing it based on political party, and the court said that's something we can't help. You can't always tell who's in which political party. You can't be sure people will vote according to their party. Race is different because historically we have a much uglier racial discrimination past, obviously, than we do political discrimination past. And politics is supposed to be ugly. It's supposed to be a fight. We're out. They didn't have to reach that decision. It wasn't an obvious decision, but they did. And they made congressional districting a political question. That means the Supreme Court, not that the Supreme Court will come out a certain way, that they won't even decide the case. If somebody files a lawsuit saying the state of Florida, for example, has drawn its congressional districts in a way that is unfair to the Democratic Party or unfair to the Republican Party and discriminates against them, the federal courts will say, sorry, not for us, political question, go fight about it yourselves. Now, that can be really disturbing, because the problem with leaving it to the political branches to fight about it is that they're the ones who are doing the discriminating in the first place. But the courts have said, this is not for us. And one of the reasons they do that is because of this notion of legitimacy and compliance and finding a place in our constitutional democracy, where they fit and can be effective. That's not to say they got it right in Rucho. And in fact, I don't think that congressional districting should be a political question. I don't think it meets the standard. I'm giving you an example of a political question so you can understand sort of how the court limiting its own power is consistent with this idea that the court is always concerned about and always wondering about its place in government. Another recent example is the killing of General Soleimani, the Iranian general. President Trump ordered his killing. Congress did not know about it and did not agree to let him do that. Why does that matter? Because Congress declares war. Congress has the power to declare war, and they're the only ones with the power to declare war. But the president shall be commander-in-chief of the Army and Navy. Of course, we now include the Air Force. It would have been silly to try to include the Air Force in 1789. It would have been like a science fiction novel. But Article 2 says the president's commander-in-chief. So the president orders the killing of General Soleimani. Congress says, wait a minute, we didn't tell you we're going to war with Iran. If this starts a war, we didn't tell you could do that. We're in charge of that decision. That is a classic constitutional question, and it is a fair one. And the Supreme Court said, I understand the dispute. Article 2, commander-in-chief for the president. Article 1, power to declare war. Congress has passed a law that says the president can't enter into hostilities without asking for Congress's permission first. This fight has been going on for centuries, and especially since the Vietnam War, when the War Powers Resolution was passed and Congress said to the president, you must report to us before you send the military into harm's way. Before you engage in hostilities, you must tell us, and we have to agree to it if you're going to stay longer than 45 days. And presidents since 1973, when that statute was passed, have all thought it was unconstitutional and have all effectively ignored it. But every time somebody goes to the courts to challenge it, the courts say, sorry, political question. Whether the president is allowed as commander-in-chief to use the military for this purpose, or whether Congress has to be involved, is something that Congress and the president can take up on their own. And to their credit, most of the time, I said presidents have ignored the War Powers Resolution. Most of the time, they do it about halfway. It doesn't stop them from doing what they want to do, but they will tell Congress and say, listen, I'll be back. We'll make sure it doesn't last longer than 45 days. Or if it's going to last longer, we'll make sure that you agree in advance. Or we promise we're not going to send any people into harm's way. We're just going to send drones and missiles. None of these things are uncontroversial. That's not my point. But that presidential and congressional interaction, the kind of thing that the courts say is your problem, can work and can result in compromise, and often does. But it is still a big deal for the courts to say, we want nothing to do with this. Right? And that's why we say, where are the courts? They are out of the business of things like congressional districting, war powers, and impeachment. Article 1 of the Constitution says the House has the sole power of impeachment. The word sole does not appear that often in the Constitution, very rarely. The other place it occurs when it says the Senate shall have the sole power to try all impeachments. And when it's the president who's being impeached, the Chief Justice shall preside. So Article 1 says this is the job for the House and the Senate. Article 1, Section 5, later on in Article 1, says each House, so the House and the Senate, make their own rules. And Article 2 says you can only be impeached for high crimes and misdemeanors. In 1993, a federal judge named Nixon, not Richard Nixon, the president, obviously, but a federal judge named Nixon was impeached. And he challenged the process. He challenged the way that the impeachment was carried out by the Senate. And he said, the Senate violated my constitutional rights because it wasn't enough like a trial. They didn't give me enough opportunity to make arguments and be heard, et cetera, et cetera. And the court said, sorry, it's a political question. Article 1 says the Senate has the sole power, and they make their own rules. We're not going to interfere. That's up to the Senate to decide. They can do effectively whatever they want. And then, of course, the question is, could they do something like flip a coin to decide if you're convicted? Maybe the courts would get involved if the Senate was so arbitrary, went so far away from the meaning of trial that it was impossible. But the court's general position about impeachment is, since you get to make the rules and you have the sole power, it's up to the House and the Senate to decide how they're going to do anything. Your response might be, well, what if they're terrible? What do we do about it? The answer is ultimately elections. We expect the House and the Senate, because they are elected, to care what people think about their choices. So when you see an impeachment proceeding, and we've seen 2 of them recently, which is unusual, but a helpful example to understand the Constitution, what we've seen is members of the House and the Senate making great efforts to explain what they're doing to the American people, to justify it in speeches and in press statements, all sorts of different ways. Why are they going to the trouble? They don't have a legal obligation to tell us what they're doing. It's because they know that we are the final check against them. We are the ones who are going to prevent them from going too far or stop them if they do something we don't like. So we don't always need the courts. The courts aren't the only way to stop these things. But it is really noteworthy when the courts say, yes, this is a constitutional question. And we know in Marbury v. Madison we said we're in charge. But in some cases, we're not going to exercise that power. We're not going to act like we're in charge. We're going to leave it to Congress and the president to resolve these things on their own because they are political questions. So what's the takeaway here? This is not to in any way dilute or minimize all the other things you are learning or are teaching about the Constitution and the Supreme Court. This is just another perspective to layer on top. But I do think that it's easier to understand what the court is doing if we understand the court's position as a little bit tenuous, a little bit threatened, in the same way that it was in Marbury v. Madison. Even in 1992, recently, in a very famous case about the right to terminate a pregnancy, about abortion rights, written by Justice O'Connor, Casey v. Planned Parenthood of Southeastern Pennsylvania, the Casey case. Justice O'Connor said, the power of the court is the power to persuade. Our legitimacy comes from our ability to convince people that we are doing things correctly and in a way that merits their compliance. That wasn't all a quote, only the first part of that was a quote. But the point is well taken. Even in 1992, the court is telling us that they care what we think and they understand that their power depends on their ability to seem like they deserve that power. Understanding that, I think, is important understanding why the court does things, even if it's not, and it should not be, an excuse for bad decisions. That's not what I mean. The way that the court makes decisions matters for its legitimacy. The quality of its explanations matters. That's why in Korematsu, the court doesn't say, we think the Japanese are dangerous. It says the military thinks they're dangerous, and we take their word for it because they're the experts. Now, we know that's horrifyingly racist. But the court could have just said, we agree. We actually think that it's important. The 9 of us think that it's important to do this. That would not be persuasive, I would think. I think most of America would read that and say, well, what do the 5 or 9 of you know? You don't know anything about this. You're not experts. Many of you didn't serve in the military. You weren't briefed about espionage threats. You're sitting in the court. You're an apolitical, non-military institution. So what do they say? We took the military's word for it. We're doing this because the court said it was the right thing to do. Oftentimes, justice decisions are a reflection of the time and place. That is not to say that the court should only care about the present effect of their decision. That's a much larger debate about how the court should make its decisions. But it's also impossible to understand what the court's doing without understanding time and place. There's no doubt that Chief Justice Marshall wanted William Marbury to be a judge. His president chose him. He was a member of his own party, and he meant to deliver the commission. But because of the place of the court at the time, because judicial review and judicial supremacy hadn't been established yet, the court can't just say Marbury wins and then take the heat for it. Different in 1954. Of course, the stakes are much higher in integrating public schools than they are in whether or not a Federalist gets a judgeship in 1801. But as a sort of an extension of the idea, in 1954, the court feels comfortable that it will be adhered to, its decision will be followed, or at least considered legitimate by the federal government, by the president and the Congress. It was not considered legitimate by the states. Many state governors said, you have no right to tell us what to do, which of course is not true as a matter of law, but they said it and they acted that way. So even in 1954, the court was taking a big risk. But had that happened in 1930, or certainly 1890, it's not likely that the federal government would have had their backs either. So time and place matters. And the last thing is that the courts have limited their own power by interpreting the Constitution to prevent them from deciding certain kinds of cases that they think they don't belong in because they are better suited for Congress and the executive. Political questions. The very decision by the courts to exclude some cases from its purview, from its power, tells a story about the court understanding where it fits. So I hope this has been helpful. You certainly know my name and affiliation, so if anybody has any questions or ever wants to reach out to me about questions of constitutional law, I'm more than happy to entertain them. I hope this was at least a little bit enjoyable and that everybody stays safe in the new year. Thank you for having me.